men's NCAA tournament first round continues and the women's tourney begins. I'm Dave Anthony. This is Fox News.
Start your day with Jeff Hood and the Wake Up Show. Weekdays on the Legend, WDXE.
All right, it's time for Stan Pierchoski and Bulletproof Estate Planning. Good morning, Stan.
Good morning. How are you?
I am just like a brand new road grader.
Okay, and that means?
It means we're making new roads.
Okay, good. That sounds good.
Yes, I like it.
I'm probably that good too.
Yeah, you feel good.
Yeah.
Feel good, looking good.
Good morning. So we're here on Friday again, are we not?
Yeah, it's Friday all over again.
Yes,
it is. Yes, it
is.
is.
And we talk about bulletproof estate planning, and we're listening to the news there, getting on there, and I just feel a need to say this. And
sure.
And I don't want to get off on a tangent, but I feel a need to say this. And I've had it with, they're just talking about the TSA and folks. I had a sister-in-law that was stuck in Orlando for over 24 hours. She has an autistic child, and it was just not fun. And
so unnecessary.
And I don't know if people understand why they're not paying the government. I mean, I'm sick and tired of these politicians. They're trying to force something that 95% of us don't want.
Exactly.
And that to do that is not serving the people, and they don't do it. They should all be fired. Oh, I'm so sick of it, tired. This regime over in Iran, I've been hearing about them since I was 24 years old.
Yeah.
I remember when they declared war on us, and nobody took it seriously. I mean, it
Yeah.
seemed like they were just a bag of hot air back then, but nobody took it seriously. But they've been in their minds, they've been at war with us ever since.
And they've done several damages.
It has done a lot of damage.
They've done a lot of
And
damage.
we finally taken it seriously and taken them out. I say good riddance. And this thing with the not funding the government because they want to open the borders. No, not 100% of the people in this country don't want the illegal aliens. I mean, they're a very high percentage of just,
Yeah.
I don't know why they take this stance. Anyway, I'm not going to say another word.
Well, I'll help you.
Yeah.
One other issue that everybody's totally in favor of except the people in charge, and that is voter ID.
Yeah.
I mean, why would you not want to know that you're a citizen and know that you can be identified? You have to do it for everything else.
That's right.
It doesn't make any sense.
And voting the right of voting is not for everyone.
Yeah, everybody doesn't have the right to vote.
That's right.
That's not what the country was set up for.
That's right. And so
if you're a citizen of this country, you do.
So they want to usurp the authority that exists and go around it. And even if they pass something that didn't require it, I don't see how it could withstand constitutional motion.
And everybody with enough sense to lick a postage stamp knows that.
Yeah. So they won't vote for it.
Yeah.
What do you do with politicians that don't do what the people want? Who's in charge of this country? We are. As soon as we realize that, which we don't seem to, the power resides in the people.
Yeah.
So that we should get what we want.
Yeah.
Anyway.
Yeah.
I could go all day about that. I'm not gonna. It makes it just depressing sometimes. So anyway, we're talking about bulletproof estate planning, and on a topic I do want to talk about, but let me first go over what's coming up, and that is my next seminar is a week from tomorrow. It's going to be.
Oh wow, it's coming up close.
Yeah, it's March the 28th. It's going to be right here at the WLX radio station, the back of the building. We do that at 10 o'clock on Saturday, so this is no different. So next Saturday, not tomorrow, right here at the WLX radio station, Will's Trust in the Nursing Home, 10 o'clock in the morning. If you want to RSVP for it, I would appreciate it. If you need to just drop in or be a walk-in, that's okay too. We have enough room.
Absolutely.
Hopefully we do. We get pretty good turnouts these days, but we'll have plenty of room. May not have enough tables, but I think we have enough chairs.
Yeah, absolutely.
So, just come on, give me a call at the office at 931-363-7222, or just tell them you're coming.
Yeah.
Give us a head count. No big deal. The RSVP process is very informal. So, anyway, I also have, I do these every other month now. Last one we did January during the ice storm, or just right after it. We actually had to postpone it a week. And so the next one I'm doing is in May. But I do have one scheduled in April because I was reached out to by the Marshall County officials in the public library there. And they have invited us to come to the Marshall County Public Library in Lewisburg on April the 25th. It's going to be a Saturday at 10 o'clock. It's going to be just like one of mine, same content, same lecture, same seminar. It's just I'm not the one sponsoring it; they are. But I told them I would help advertise that. So if coming to Marshall County is a little easier for you, we're going to be there on April the 25th, 10 o'clock. Same seminar, Will's Trust in the Nursing Home, Saturday, 10 a.m. I'll bring that up a little more after we get past this one, and that one's the next one coming up. I'll talk about it more. So, all right. So what do we want to talk about today? I've got a topic
Okay.
that I think, if I remember right, I've talked about it before, but I think when I talked about it before, I kind of left it open and said, I'll talk about that more someday.
Sure.
Okay, so this is someday for that topic because I've dealt with it here since the first of the year on something. And the topic is this. You know, when we talk about, I do a lot of asset protection trusts.
Yes.
Okay, when you do an asset protection trust, you're protecting your assets from future creditors. And the future creditor most people are concerned about protecting their assets from is long-term care.
Yes.
Now, it also protects you from other creditors,
Yeah.
but most people don't have the other creditors. You know, other creditors are like, you know, you wreck your car, you get sued, and you're sued above your policy limits. You know,
Yes.
so you got $50,000 property damage, and someone sues you for $100,000. You can be exposed for $50,000.
Right.
And if something like that happens, you know, the stuff in the asset protection trust is protected. They can't get at it.
Right.
But that doesn't happen to too many people. Here and there, now and then, but
Yeah.
for the most part. It does happen, but for the most part. And if you're in a business, you can get sued. So it protects you from all creditors, but the 99% of the people worry about is long-term care. And so when you do the asset protection trust, you're doing estate planning, but you're kind of getting yourself ready way in advance in case that happens.
Yes.
Right? Now, then we move into strategies that we use if you don't do that way in advance. We call it crisis planning. Okay.
Right.
In other words, pre-planning is the trust. That's when you do it when you're not in care and you're not really heading there. You just think, you know, if one of us go to care, you know, a spouse, if one of us go into some kind of care, we want to be in a good position financially if that happens.
Sure.
So it's a big if. But then you have folks that are actually in care or knocking on the door, so to speak. Now, pre-planning is not really the best option because we need time for that to work.
Yes.
So pre-planning crisis planning is when it's imminent. We're there.
Yes.
And so things are a little more time critical, and we have to resolve the situation. We have crisis planning strategies. Well, what I want to talk about this morning was a crisis planning strategy that I don't do. I'm not a fan of it. I don't recommend it. But I said one time I would go into a little more detail as to why I don't.
Yeah.
So I keep loose notes about what I talk about on the show, so I don't like talk about the same thing 2 weeks in a row.
Sure. Sure.
So, so one of the strategies that's out there, a lot of people have heard about it because the reason I'm doing this is because they bring it to my attention, and it's like if you got a spouse that's in care,
Yes.
husband or wife, in care, there's a strategy where they say, well, they can get divorced. Okay.
Yes.
I'm not sure what they call it. I'll just call it the divorce strategy. Okay. Now, I'm not a fan of that because I don't think it works. And if it does work, I think it's just because you got lucky. But legally, it won't, and I want to go over it. And it's actually been identified by at least 2 states that I know of that I've read court cases on where they did not honor what the thing was. Now, to talk about it, you have to have a little understanding of how divorce works. Now, if you're out there and you had a divorce, then you probably know. But when I talk about divorce, I'm talking about property settlement. I'm not talking about who gets the kids. That has nothing to do with it. And usually people that are worried about long-term care or in long-term care don't have minor children anymore anyway. So you got a spouse, when you get a divorce, very few divorces go to trial and stuff like that, right? They almost all settle. But when you have a divorce like this, where you're not going to fight about it, or if you have a divorce normally that you're not going to fight about it, you just say, okay, we're just going to call it quits, we're going to walk away. You sit down, you may negotiate a settlement, a property settlement. Who gets what? Now, in Tennessee, we are not a community property state, which is 50-50. But when you've been married for a long time, anything over 10 years, the theory is most, if not everything, is jointly owned anyway. And so, we have something called an elective share. So the spouse is really much, it's not exactly 50-50, but it's kind of close because the statute says in Tennessee that when couples part, when it comes to property, there's an equitable division of marital property.
Yes.
And almost all of it is marital property when you've been married for any length of time.
Right.
So you divide it. And pretty much, like I said, it's not strictly half and half like community property. It may lean one way or the other for a valid reason. But that's just rule of thumb, it's pretty much divided. Okay?
Yeah.
Now, and then that's called a marital dissolution agreement where you say, okay, you don't want the house, I don't want the house, we're going to sell it, we're going to divide the money.
Yeah.
Or you want the house, you get it, I'm going to buy your my half, I'm gonna let you buy my half out, or something like
Yeah,
that.
something like that.
Just,
Yeah.
just kind of negotiate.
I've run across those.
Yeah, and you end up with an MDA, stands for marital dissolution agreement. Now, that MDA goes to the judge, and the judge has to approve it. And usually, it's pretty much a lick 'em stick 'em, because, I mean, the judge has to, it has to be equitable. He's bound by the statute that says an equitable division of marital property. But sometimes the way they'll get to that is, you go to court, they'll present the MDA to the judge, and the judge will pretty much ask the parties if they're happy with it. Do you consider this an equitable distribution?
Yeah.
And people say yes, and I don't know if the judge may not even give it much of a look, because if the parties are happy, he has less reason to be concerned.
Yeah.
Right? So, the parties are happy, and the judge will sign the MDA, and then that becomes a court order, and whatever you're supposed to do in that MDA, you're supposed to do it. Like a lot of times, if they say, we're gonna sell the house and divide the property, the MDA will say, we're gonna sell the house in the next 6 months. Gives you time to sell it and stuff.
Sure.
But you have to do it. Now, that's kind of how it works. You have this MDA, but part of the judge's job is to make sure that MDA complies with the statute. And the statute says, I'm gonna say it again for about the third time, an equitable distribution of property. So he's not bound to half and half, but
Right.
whatever's considered equitable.
Yeah.
And there's some, like I said, it could be some percentage other than 50-50 if there's an equitable reason for it.
Right.
If you go in there, you get people all the time that get divorced and say, if I'm going to divorce you and I'm going to leave you with nothing. I'm going to take everything you own. And, that doesn't happen because you can't. The law doesn't allow that to happen.
Yeah.
And so, now there's a strategy of if you've got a person in care, we're going to get a divorce. Now, first thing I need to say is it's not a divorce because we don't love each other anymore. We want to be apart. We want to be divorced and live our own lives. It's a strategy to adjust their economic situation to minimize and mitigate the impact of the high cost of long-term care, because the theory is one of the spouses is in care. And of course, when a spouse is in care, they're a black hole of cost to the tune of about $10,000 a month.
Yeah.
And if you want to do the math, you can figure out how much you're worth and how long that rate of bleeding is going to be, how long you can withstand that rate of financial bleeding. And for most people, there's an end in sight. And so they don't want to get wiped out. So what they do is they have they go for a divorce, they go for an MDA, a settlement, okay? But then when they do it, they heavily weigh the assets in favor of the community spouse, the one that's not in care.
Yes.
And it kind of leaves the institutionalized spouse with nothing much but other than their income, their Social Security, whatever.
Right.
And then and now, the flaws I see with this is, first of all, it shouldn't get past the judge. But so if it does, if you've done this, or if you know of a couple that did this and it worked, in my opinion, it may work for just a little while, but it won't work forever because it's slipping through. And I don't want to do anything where I'm just counting on them not seeing something.
Sure.
So what happens? You have this divorce decree, this marital dissolution agreement. You got to present it to the judge, and the judge should look at it, and the judge should see that it's heavily favoring. It's an inequitable settlement. It's heavily favoring one person.
Yeah.
Now, if the judge would say, why is this all the stuff going to this spouse and this spouse being left with nothing but their income? If the response is we're trying to not have to pay our TennCare bill, that's not going to fly. I mean, that's not a valid reason to be doing this, right?
Why is that not a valid reason, Stan?
Well, I mean, it's a desirable reason. It's a desirable reason.
Yes, it's a
Well,
desirable
let me put it this way. It's a valid reason to not want to have to get cleaned out.
Right.
It's not a valid reason to shift an MDA heavily in one person's favor. So this is not, what's not valid is this solution.
Yes.
Okay. The end result is a valid reason for doing it, but don't go this route. And so it should get caught by the judge, but I think a lot of them get through. Now, when they get through, here's the second thing that's going to make them fail. The long-term care agency in every state is starting to pick up on that. They know to look for that. Now, there's a case out of Illinois that I've spent a lot of time reading, and it does exactly that. And that court says, the 5-year look-back rule and penalty period applies to all transfers that are done in the last 5 years, including transfers of a marital dissolution agreement. And so they said, now, it's not like, and you did give it, and so the argument is, well, we didn't give it away. We have a marital dissolution order from the court saying it all goes to this person. And they're taking the position that, yeah, but this is a divorce by agreement. MDA, the letter A stands for agreement. marital dissolution agreement.
Right.
And when you agree to let one spouse have everything, what they're interpreting this as, and I think they're correct at this, is you are entitled to 50, roughly half.
Right.
You're entitled to an equitable distribution, meaning you're entitled to more than you're taking. So you are voluntarily agreeing to this and allowing the spouse to have it all. They are calling that a transfer, and you get the transfer penalty for doing that. So you didn't get anywhere. You got the divorce, you went through all this, you got some shady attorneys that said, yeah, let's do this, and they charged you for a divorce, and it's not going to work. And now it's hard to come back from.
You're gonna bite them, yeah.
So don't do that. I mean, if you do it at your own peril. I don't recommend it. I don't like it. I don't do it, and things go south, and now you're not eligible, and you come to me and say, can you, because I sometimes will inherit do-it-yourself applications. I have to give that a lot of thought. I'm not sure what the comeback for that is, to be honest with you. But,
I don't know.
I mean, I have to give it some thought. The first thing that comes to mind is the cooperation of the spouse you just divorced to give some property back to cure the penalty period. I don't know if that's going to happen. I mean, maybe because it's a friendly divorce in the first place, maybe that's available. But normally in a regular divorce, going to the divorced spouse for help.
I have to, I guess, commend the creativity here, but again, it's not going to fly.
Again, you're relying on first getting through the judge, and two, getting through 10-care.
Yeah.
And now they know to look for it.
Yeah.
And that analysis from that court in Illinois is precedent that they're relying on. And so it's not going to work. You can do it, but you're not going to be in a good place when they deny, or they call those your transfers. Everything you gave to the spouse in this divorce, we're calling a gift.
So they would just potentially reverse what you did.
Well, it's a divestment. We're calling it divestment.
Right.
So now you're penalizing. There's nothing there. Now, my argument would be, if I were to try to find some argument positive in this scheme, which I tell you I don't like, it's like, well, wait a minute, we have an unlimited transfer to spouse that we're allowed to do. You can transfer an unlimited amount of property to a spouse, right?
All right.
Is this person a spouse? We're in the course of a divorce. When the judge signs the marital dissolution agreement and the divorce papers, you are divorced. And a lot of times the property hasn't transferred yet. It's ordered to transfer, but it hasn't.
Okay.
And so the question is, are we making a transfer to a spouse? Because when did that person become a spouse no more?
Right, right.
So, and I think there's an argument there that's not favorable for that. So I can't think of a good way why that'll work. I mean, you might do it and just get lucky and get through, but I never do anything depending on that.
Yeah, yeah.
Now, you're right, the creativity, why bother being creative with this stuff? We've got a handful of tools that we can use that work perfectly.
Yeah.
That work within the law, because it's their law that says we can do it. I mean, the 10-care law allows us doing it. There's no need to get creative like that. Now, we can get creative sometime with those strategies by tacking one or two of them, or three of them together.
Right.
Stuff like that.
But you're still working within the framework of what's legal.
Exactly. This is just, and I see some stuff written, like on the internet, that talks like, this is the greatest thing since sliced bread, and this will work and help, but they don't go into that detail.
Yeah.
They just say, we get a divorce, let everything go to the divorcing spouse. You go to the nursing home without anything, and therefore it's like, well, it's $10,000 a month. Well, sorry, I haven't got anything. I'm broke, so you'll just have to pay for me. The state's just going to have to pay my bill for me. Well, good luck. Good luck. I mean, because and again, their system is designed. They thought of a lot of that ahead of time. Now, I don't know if they actually thought about this, but that by pigeonholing it into a divestment, then they've thought of that.
Sure.
A lot of people say, well, if I have to go to nursing home and they're going to get everything, I'm just going to give it all away. I'm telling you, they thought of that before the ink was even dry on the original Medicaid Act and the 10-care Act. That is not creative thinking on your part. It might be creative to you at the time because you hadn't done it before, but they definitely thought about that when they put this thing together, because that's human nature to do that.
Sure.
So they have check and balances that prevent you from doing that, and that's that penalty period we talk about. You don't want to get, if you get into that, if you go down that hole and you get stuck with a penalty period, that's hard to fix.
Yeah.
It's fixable sometimes, not always, but it's fixable, but it's a lot more effort. It's better not to have the penalty period in the first place.
Yeah, yeah.
I can deal with the asset better than I deal with the penalty period for giving it away.
So by far, and we've said this many, many times with you, the pre-planning is so much better before you get to crisis planning.
Yeah, Excuse me, I took a swig of coffee there.
That's okay.
I think I inhaled it instead of swallowing it. I don't know why. But you are absolutely right. Now, because when you do the asset protection planning, we're not doing everything we're doing in estate planning for long-term care. We're also putting property in trust so it goes to the people we want it to go to. It all works together because when you have if you have a will, again, if you have a will, which is a testamentary instrument, and you put in there, I leave everything I own to my 3 kids, okay?
Yeah.
You have to extrapolate on that and say, does that not presuppose you have everything you own when you die? Because it's not going to them until your death, because it's a testamentary instrument. That's what
Right.
testament means. And so, at your death, everything you own goes to your 3 kids, right?
Right.
Now, that supposes you have everything, right? What can happen? So that brings the question: what can happen during my lifetime that could exhaust my estate? So when when I pass away, and my will says everything I own goes to my kids, I don't have hardly anything anymore. Well, but when I wrote the will, I had what I had, and now everything is a much smaller everything than the everything I said when I wrote the will. Does that make sense?
Yes.
And so, enter long-term care. You know, what could come up during my lifetime that could exhaust my estate? Enter long-term care. It is catastrophically expensive. It's going to happen while you're alive. Maybe a statement of the obvious, but I feel like I need to state it.
Sure.
And so, when you do this kind of planning or the pre-planning, we're just concerned that if long-term care enters the picture, we want to be prepared about it. But what we also want to do is put it in this trust, because it's an asset protection trust, which does the same thing as any other trust for the most part. And at our death, it will not only distribute the property at our death, but because it's in an asset protection trust, we know that at our death, the property that is in this trust will be there to go to the kids because it's an asset protection instrument.
Yes.
So when you're doing this kind of planning, it's not just solely doing the trust because in case you go to the nursing home, you are positioning your financial situation so that if that happens, that creditor arises in your life, you are mitigating the impact of it.
Yeah.
And if you do it, when you're married, you're literally eliminating the impact of it.
Yeah.
There's no impact with it. So, you're still, if you're going to long-term care, there's the impact that you're going into care. But financially, we can seriously mitigate, if not completely eliminate, the financial blow that happens. And so that's why the asset protection trust we talk about in the seminar is so popular.
Very good.
Because at death, it does the same as any other trust and distributes probate free, and you can have a say in where it goes, and how it goes, when it goes, under what circumstances it goes. You can protect it, how it goes to your kids, or you can just give it to them straight out. But with the asset protection trust, we know that those big ticket items that are in the trust are going to be there,
Yeah.
even if long-term care enters the picture.
Yeah.
They won't be able to get at it.
As we were about to come on the air with you, anticipating conversations, I just did a little AI question,
Okay.
and basically it said estate planning topics, and just said, just give me that.
Yeah.
And of course, most of this we've talked about one way or another, but there's areas of concern. You've got core documents, the documents that are put in place for all these.
That's like the trust.
Yeah. So you've got wills and trust, revocable living trust, durable power of attorney, healthcare power of attorney, and living will and advanced directives. All of those you deal with, I'm sure.
That's right. I don't do much of the living will. Living will is kind of like your preferences if you're in the hospital. Like
Sure.
Dietary. Like, hey, if I'm in the hospital, don't bring me any pork, or
Yeah.
or other things like I don't want to. I object to a blood transfusion for religious reasons or something. Things like that. Preferences.
Right.
I don't do much of those. You can do them. They're not exactly. They're a little less legal documents in a way. It's an announcement of what you want, preferences. But the advanced care directive is the power of attorney for healthcare.
Yes.
And so when you talk about the power of attorney in Tennessee, and I think just about in every state now, it's bifurcated into 2 powers. One is for healthcare and healthcare only.
Right.
And the other one is for everything else. It's called the general durable power of attorney. That's for everything else other than healthcare.
Right.
People call it the financial power of attorney. It's a little more than that, but that's a good enough name for it.
Sure. Sure.
But it's more than just writing checks. I mean, it's like buy, sell, sue, be sued, invest, everything other than healthcare.
Yeah.
And the advanced care directive is the end of life, quality of life, and
Sure.
resuscitative measures and stuff like that.
Right.
But all the other ones we do, because they all support the plan, because when you have a trust plan, we have to look at things during life, and then we have to look at things after death. And something like your power of attorney, those are during life documents. We call it incapacity planning.
Right.
You know, power of attorney expires at your death.
Right.
I can't tell you how many times people come in to me and Dad's been gone for a month now, but I'm his power of attorney, so I'm still writing checks on his account stuff. The bank shouldn't honor that. And legally, the power of attorney expires at death.
Yes.
Because you're acting for somebody, making decisions for them. At death, there's no more decisions to make, right?
Right.
You're just dealing with property and distribution and stuff like that. So, so the incapacity planning is the stuff that happens during life. And if you can't make your own decisions for some reason, you want a trusted loved one making them for you, both financial or health.
Right.
Then at death, there's sort of like a line drawn in the sand at death, where the power changes. Now, if you have a trust, you have a successor trustee. Now, it could have been the same person that was your agent in the power of attorney. It often is. And so now they have control over all your property for distribution in the document that says how I want it distributed.
Yeah.
So, you know, those are all ancillary documents, we call them. They all support the trust plan. The trust is the core document, but we want to support the trust plan. And we even do a special kind of will called a pour-over will. You know, there's many documents in there.
Wow.
I mean, like 8 or 9 as far as many, but they're all the things that support the plan in the first place that make it work.
Yeah.
So yeah, that's right. I mean, those are the generic topics. I didn't hear you say asset protection, but
Yeah. Well, actually, that's under the next one. You've little headings there: probate and avoidance. Understanding what probate is and how to minimize it. I thought that was kind of interesting that all of a sudden I didn't mention that, but the idea is to minimize it.
idea is to eliminate it.
To eliminate it, okay. Yeah.
And if you properly fund a trust, it is a 100% probate avoidance technique.
Using trust, TOD, transfer on death, and POD, payable on death. Those are terms, I guess, utilized in those documents.
POD is like a bank account.
Okay.
It's kind of like making your bank account a beneficiary-driven instrument. It
Yes.
pays on death. TOD only applies to real estate, transfer on death.
That's right.
Now, we don't have TOD in Tennessee. We have proposed that law. I've read it. I like it. It's never been enacted yet.
So what do we have in place of that?
The deed gets transferred by the executor of your will or the successor of your trustee.
Ah, okay. All right. So it has to be done by.
It gets transferred, but it has to be transferred.
Okay.
Transfer on death is kind of like an automatic transfer.
Okay.
You know what I mean? It's kind of like a pay on death.
All right. I got
But
you.
it's a deed because we're not paying anything. We're transferring the ownership on death.
But Tennessee does not do that.
Here's what it's real similar to. Let's say you have husband and wife in Tennessee own property.
Yeah.
When husband and wife own property in Tennessee, they own it by tenants by the entirety with right of survivorship.
Yeah.
Now, at death of one of them,
Yeah.
like you and Teresa, right?
Yeah.
And we'll pick on you. I always kill the husband off first in my office, or put him in nursing home first.
There you go.
So we killed Jeff off.
Yep.
What happens to the piece of property that him and Teresa own as tenants by the entirety with right of survivorship?
Well, in that case, she would have the property.
The answer is at the moment of death. At the moment of your death, all ownership vests with the survivor.
Yeah.
Okay, so there's no transfer. You didn't transfer anything. You didn't have to do anything. It happened automatically.
Right.
Okay. Now, that's great. That's called right of survivorship. It's not exactly transfer on death, but it works a whole lot.
Yeah.
Now it all resides with her. Now at her death, then probate's an absolute surety because she owns it.
Yeah.
And that has to transfer. Now, she could put a transfer on death clause on it and say it goes to my 3 children.
Yeah.
Now, it's similar. It doesn't go through probate because the best way to think of it is like a beneficiary. And a beneficiary, when property passes, because you name a beneficiary for the property to go to, now it's passing by contract. You have in a contract for whoever holds the property to transfer. Okay. And it's like a bank account. If you put pay on death or a life insurance policy where you say beneficiary is so-and-so, that doesn't go through probate. They don't call the court and say, hey, can I distribute this piece of property? The answer is no. You have a contract. It passes by contract.
Oh, wait. I may have missed something or a little confused about something because we said that Tennessee does not have a transfer on death law. But in effect, that's what we're doing if we got tenants in common with the right of survivorship.
Well, not exactly. That's not a transfer. It's the mechanism that transfer where it goes from one to the other is called right of survivorship.
Yeah, that's right. Because she's already an owner.
The actual transfer is to transfer the deed to somebody to a non-spouse,
Yeah.
but we don't have that yet.
Okay. Okay. It's to a non-spouse.
And I think we will. I don't know. It was actually proposed over a year ago.
Really?
Yeah.
Okay. I can see that.
And but I think it will because a lot of states do have it.
Interesting.
I think it's
So,
it's
but
beneficial to
is
have it.
this
It's actually cool.
something that would have to be written in the deed if
Yes.
you wanted to happen that way?
Yep, it would be in the deed.
So it would be an additional clause in the deed
That's correct.
that we have that. Okay, interesting.
And I know you see stuff like that in old deeds where it says, at my death I want this to go to my son.
Yeah.
That doesn't necessarily transfer it, but they're not what we're talking about.
Right.
But a lot of states have that transfer on death. It'd be nice when we get it someday.
Interesting.
I mean, you can still give it. You can say in your will or your trust that okay, I'm leaving the house to my son Joe, right?
Yes.
You can do that, but now the executor or the successor trustee is going to have to develop a deed that says from the successor trustee of Jeff Hood's trust to my son
Right.
Joe.
Right.
And so it's just another step that has to be done. The transfer on death is very similar, but it kind of you still need a deed to transfer it.
Yeah.
But it transferred by a different mechanism. It's not your successor trustee in a probate avoidance, and it's not an executor in a probate proceeding.
That's interesting.
Yeah.
Yeah.
I think it'll be helpful if we ever
A
do
little
it.
bit. A little bit.
I don't know what the holdup is. I didn't look at it that much, but I do know they haven't. So yeah. I mean, and now that's the kind of planning that we do. But what we can throw in the mix is just what I was talking about for the last 20 minutes. We can throw in the mix this protection in case
Right.
this monster of long-term care rears its head during our lifetime.
Right.
And if it does, we can still make sure that our kids get some of our stuff, if not all of it.
Right.
If we do the asset protection trust, and you have to do the trust right, which I do, and do it with a little bit of time,
Right.
to build in there, because the trust needs some time to do all its work.
Right.
So anyway, that's
Okay.
and that's the problem that the asset protection trust solves. It protects the maker of the trust from their creditor during their lifetime.
Interesting.
When we do a will or a revocable living trust, that doesn't do that. That's just one limitation, the living trust. So
We've gone through a lot of things. I've learned a lot, and it's just amazing, really, how many things have to be considered.
and I see your honorary law degree hanging on the wall.
I got an honorary law degree. Yep. I'm an honorary colonel as well. I got one of those way back somewhere along the way. How often would you recommend? If you already have some of your planning done, maybe even you got your trust done, maybe even got the asset protection trust, but is there a procedure or a timing to review things, or how often should you review what you got?
Well, if you search the internet, sometimes it's suggested you should probably review your stuff every 3 years.
Yeah.
I don't know. Here's what I suggest. It's time to review it when you have some life changes.
Yeah.
Now, some of the life changes you have are birth of children,
Yeah.
graduation of children, college events, right?
Yeah.
Death in the family, divorce, or a marriage. I mean, these changes all spark things that you might need to do or undo.
Right.
So I don't know that I would put a time on it. Okay, and sometimes I think they say every 3 years because make sure everything complies with any changes in the law.
Yeah.
And I can tell you right now, there's hardly any changes in the law. I mean, that happens rarely in this field.
Sure.
What changes is like in this long-term care thing that we do. Sometimes we have court, either the administrative court decisions or higher level courts. Like the appellate court reviews that will interpret things for us that we now know how the courts are going to interpret things better than we did before, and that could possibly cause some adjustments. But still, it doesn't change much. So every 3 years, I don't know. I mean, it wouldn't hurt to do that, but I think time, circumstance changes. Now, if you have a trust and it's got 20 years of age on it, you might want to go look at it. You may have all kind of things in there for the kids because they're minors, and now none of them are. Stuff like that.
Quick question, and you may not want to address this. I don't know, but it just crossed my mind. Long-term health care insurance.
Yeah.
Do you have a take on that and give or take as far as advisable, not advisable, or combination, or what's your?
I'll be more than happy to take it.
Yeah.
Not a question you can ask me that I will dodge.
Well, all right. Well, not good. No dodge here. We're just going to answer this question.
Estate planning attorney.
You're estate planning, and okay, so there is a product out there in the insurance business for long-term care.
There is. And I don't want people to be confused because a lot of people think, well, I've got a rider on my Medicare that pays for long-term care.
Yeah.
There is no such thing. We have to go, I mean, and you're going to get mad at me for saying that, but if we sit down and read that, whatever that is you're talking about, I guarantee you it doesn't do that. There is a product, though, it's called long-term care insurance.
Right.
It is an insurance product.
Right.
Just like you buy term life or whole life or, anything, any kind of insurance product. And this is a special kind of insurance that pays a certain amount, maybe 60% of the cost. Now, some people have these old ones that pay 100% with no time limit.
Yeah.
If you got those, man, they're great. Hang on to them. But the ones you can get now, and there used to be over 100 companies that sold these. Now there's less than a dozen.
Okay.
Nationwide. And anyway, they sell long-term insurance, long-term care insurance, and the end result of it is, if you go into care, you can make a claim on your insurance, and they will pay anywhere from 60, maybe 70% of the bill.
Okay.
Now, between that and your income, what it does is it kind of keeps you from having to sell other assets to pay for your care.
Sure.
Now, it also has another, and most people when they get it, you have a time limit for how long you can get this payment. Because it's not it's not like a death benefit. You get term life, you say, I get $300,000 policy, death benefit.
Right.
Which you don't own, right? It's not yours.
Right.
You have to die for somebody to get it.
Right.
So, but it pays to them, lump sum, boom, it's over with. This is not that. This is a payment of long-term care. So it's going to go on for a while, paying it every month, right?
Right.
So, and most people buy it for about 3 years, but there'd be no reason whatsoever to buy it for longer than 5 years. I'm not going to get into the reasoning for that, but because after 5 years, we're going to have taken care of paying for it anyway.
Yes.
But I won't get into that because that's pretty heavy. But just take my word for it for now. But what it can do, another big advantage it has, is if you go into care and you have you fall short of this 5 years. Let's just say it works. This long-term care works very well with an asset protection trust, because the theory is, I always tell people at my seminars, the goal is, if you do the asset protection trust, put your property in this trust and stay the heck out of the nursing home for 5 years, 60 months, right? That's and people laugh when I say that, but that is truly the goal. Put it in and don't go into care for 5 years. Now,
Yeah.
that begs the question, and I get the question so much, I actually made it a slide at the end of my presentation, that what happens if we fall short of the 5 years, okay?
Yeah.
Well, let's do it. I talk about that at my seminar, so if you want to hear the answer to that, you come to the seminar and you get it, because you'll love the answer to it. But let's put it in perspective and say, we're talking about falling short of the 5 years, but we have long-term care insurance.
Okay.
Well, if you fall short of the 5 years, under any circumstances, the goal now is to get to the 5 years.
Mm-hmm.
And so before you file a 10-care application, right? Because if you file it before the 5 years is up, they're going to look back 5 years, they're going to see all this stuff transferred to your trust, and they're going to hammer you to death with a penalty period. So we want to file the application, but not till the 5 years and 1 day, technically.
Yeah.
So, but if we make this trust and 3 years later we go into long-term care, the last thing you want to do is file a 10-care application, because they're going to look back 5 years and they're going to see that 3 years ago you put $1 million into this trust, right?
Yes.
And they're going to say, boy, that's a pretty big it's a big penalty period, right? Okay. That's a big penalty period.
Yes, it
And
is.
the penalty period is really, the penalty period is not capped at 5 years. People
Yeah. say,
say, well, the 5-year rule, you should get a 5-year penalty period. No, your penalty period is based on the value of what you give away.
Yeah.
When you put $1 million in a trust, you're looking at about almost a 10-year penalty period.
Yeah.
Okay, that's not capped. So, but if we don't file the application, it's going to be capped at 5 years, no matter what we do.
Right.
So we want to get to 5 years. Now, if you have long-term, so the strategy we use mostly is divest and wait. That's saying put it in trust and stay out of the nursing home for 5 years. The next kind of strategy, if we can do it, is called divest and insure, which means we have long-term care insurance.
Yeah.
Now, if we fall short, let's say 3 years, everything goes south, we go in the home, then this will pay 60 or 70% of our bill, coupled with our income, will probably get us 90% of the way there. The rate of financial bleeding is minimized, and we get to 5 years. Now we get to 5 years, now we're gonna file for 10 care benefits, and we'll be eligible, and we have saved everything in the trust.
Yeah.
Because that's the fear, put it in trust, and then something goes south before the 5 years is up, because I gotta have that 5 years, because without it, that's a government imposed time period. I cannot get around that. I wish I could. If I could, I'd be retired by now. Or they'd be lined up from my office to Lawrenceburg trying to sign up, if I could do that, but I can't.
Yeah.
But we have strategies to get past that hurdle, and we have a lot of good ones that work. Now that's one that would be great. So long-term care insurance is something you have to go buy.
Yeah.
I'm not promoting one over the other. I can't think of all the different companies that do it. I know I got one through Nationwide,
Yeah.
because I like the terms and conditions of it. They are a little different, the people that sell it. And I like, there's one that lump sum pays, and there's one that reimburse pays. And I didn't like the reimbursement thing, because every month you kind of list what your costs are, and then they reimburse.
Yeah.
And the other one just pays a certain amount for a certain length of time. And so
Yeah.
you can, but the problem with getting long-term care insurance is you can either, if you're too old, they won't give it to you. They cap it, it's age capped.
Yeah.
And it's definitely, don't like to give it to you if you've got a lot of problems.
Yeah.
Because they're insurance companies, they don't like taking risk. Now, if they did give it to you, if you're older and have problems, the premiums would be so high that you probably couldn't afford it. And it is expensive. Now, it is expensive as far as insurance goes.
Yeah.
It's not as expensive as long-term care.
No.
So, cost of long-term care insurance, ballpark, is roughly 1 to 2 months in a nursing home. So we're talking about $10,000 to $20,000 a year. The premium for the year is like that. So let's just split the middle and say it's $15,000 a year or $10,000 a year. That's expensive for insurance, but it's not as expensive as being in the home.
Yeah.
That's $10,000 a month. So if you've got long-term care insurance, it's a great tool. Hang on to it. It will work very well with what we do.
Yeah.
It will really work well with what we do with the Asset Protection Trust. Now we have an absolute guarantee that everything in that trust is not going to be disturbed. Now, the other alternative is don't go to the nursing home for 5 years.
Yes.
Then everything is absolutely guaranteed not to be disturbed.
Yeah.
But since everything is a what if on that, we don't know, right?
Right.
You don't know if you're going to end up there. You don't know. Accidents put people there. If you get some kind of sickness or disease, I mean, nobody sees it coming, or typically you don't.
No.
The only thing you see coming sometimes is you get diagnosed with the early onset of some sort of dementia.
Sure.
And so you know it's progressive, and you know it's coming, and you know it may get to a point where you need care because you don't remember how to do certain the activities of daily living, right?
Right.
So that's about the only thing I know of that you're going to see coming, unless you're maybe have some kind of congenital thing you're born with. You know that if it gets bad, you're going to have to need care. So anyway.
Well, we got one of our regulars that wants to talk to us.
Hopefully that answered the question about long-term care.
Yes, indeed. Good morning.
Yeah, a key term that got my attention was terms of care. I know of a situation that goes back 13 years ago, and this lady had assured me that she had long-term care. After she died, I asked her husband, I said, I thought you had long-term care where she could go into a nursing home. And he said, well, they spelled out in the policy what it had to be for. It was things like cancer, diabetes, and said she was dying, but she was never diagnosed. So that's really an important point to make sure it's for, whatever you think you'll cover. A second thing has to do with, is there a statute of limitations on, let's say, somebody not settling in a state, for example, either the trust or a will. Someone called in today for Nancy this week, and it reminded me of a personal situation I knew about in another state. And the girl decided after she got married, she wanted to check, and she evidently was a child when her parent died. Well, before it was over, Dave Ramsey was saying, you need to contact whoever's the executor of the will, which was her uncle. He says, my gut level feeling, if you have anything coming, he's got a civil issue against him. And he said something about, it sounded like the executor was at fault, but I thought that was interesting. A lot of young people have this idea, oh, I'm not going to worry about it, I won't need it, and all of a sudden they do need it. Thank you.
Okay. All right. Thank you now. I'm not 100% sure. You maybe know.
Number two, I'm not sure. I'm not sure about that one. But let me go back to number one. I think what she's talking about, there's two different things. There's long-term care insurance, which will pay your bill if you go into long-term care. Now, that insurance is not condition specific.
Okay.
Now, however, you can buy insurance. You ever hear anybody say that I got a cancer policy, or I got a cancer rider, or I got That's when I hear about cancer. You know what I mean?
Right.
Now that is what she's talking about. You
Yeah.
have insurance. You're insuring an event,
Right.
and the event is cancer.
Yeah.
Now, if you go in there because, I mean, if you let's say if you get some other disease like leukemia.
Yeah.
Well, they're going to say, well, leukemia is cancer. Sorry.
Yeah.
That's
Something
cancer.
besides
Sorry,
cancer.
That is a cancer. Yeah, that's what for. And you can get just like you have accidental death.
Sure.
Or dismemberment. You know,
Yeah.
if you die from an accident or get your arm cut off, that insurance triggers and pays.
Yeah.
But if you get sick as a dog and you die, it's not death. It's not accidental death or dismemberment.
Right.
So insurance is usually for a purpose, and that's what life insurance. Term life insurance is when you pass away, but it's also they have limitations. You can't pass away by choice, like suicide. There's certain clauses that it's going to be death. But there's other ones that during life, something happens to you during life, you can get a policy for that.
Sure.
I submit you probably could get a policy for anything you can think of.
Yeah.
Like Lloyd's of London over there, they pride themselves on they would insure anything.
Yep.
And they did things like, remember when Space Lab was falling apart and falling to Earth, and they said they would insure your property if a hunk of Space Lab landed on your house.
On your house.
I don't know how they figure the premiums, but they get the bean counters and they come up with something.
They come up with something.
And they figure out that if that does happen, we'll still come out good.
They do that. If you've ever been to like a golf tournament or something like that, where they have a $50,000 hole-in-one. If you happen to hit a hole-in-one on that hole or whatever, you could win this or win a car.
Yep.
Something like that. It's insured usually by Lloyd's of London or something like that.
But the point is, you can get an insurance policy that insures you for a specific event, and it just stands to reason that the terms and conditions of that policy will only pay for that circumstance.
Yeah.
But long-term care insurance does not if you go into long-term care, it doesn't matter whether you're there for dementia, some kind of multiple sclerosis, physical injury where you can't move around and you need help. But if you're in long-term care, then they'll pay.
Yeah.
And I've seen it done.
I've
seen it do it for several different conditions.
Yeah.
And the condition was never instant. So I think that's where the confusion is. But you to the word term doesn't mean a term when you say long-term care.
Right.
It means long-term care is nursing home or assisted living, really.
Yeah. Yeah. Absolutely.
But if you have it, it's a great tool to have. I encourage you, if you have it, hang on to it.
Yeah.
Now, most people I talk to, it's probably a little too late for them to get it. But the good news is, even if you don't, I say let 10% have long-term care. It's actually less than that.
Yeah.
Long-term care insurance. But if you have
Well,
it,
like you said, it's not cheap.
if you have it, hang on to it. If you don't have it, it's not the end of the world. We can still do things.
Yeah.
We're a little more at risk during that 5-year period when we do the trust. That's why I say let's do the trust now. Okay, don't wait till you're looking at long-term care. So let's take you.
Yeah.
You and Teresa. I know you're younger than me, but I don't know the age, but I could probably guess, and I'm not going on the age. But let's say you decide to do this asset protection trust.
Sure.
That would be a good choice for you at your age, and here's why. Because you're not in the nursing home, you're not knocking on the door, you're relatively healthy.
Right.
I mean, you're kind of coming up on retirement years, or
Sure.
not too far away.
Yeah.
And you're still basically kind of healthy.
Yeah.
I mean, I know you can tell me, yeah, my knee hurts or my back is sore, I get sinus infections every year.
Sure.
I mean, or whatever. You got all that stuff. That doesn't put you in long-term care.
Right.
But you're basically healthy, and so statistically, clearing this 60-month period, this 5 years, is kind of in the bag, or at least statistically.
Yeah.
In other words, you have probably got a 96% chance of clearing this 5 years now.
Yes.
If you come to me and you're 89 years old, you already got some bad issues going on, then I have to take a wait and see approach. It's like, can you stay out of the nursing home for 5 years? I don't know. We have to wait and see.
Yeah.
I hope you can, but we don't know. When I'm talking to you, it's still a wait and see, right? Because I don't have the crystal ball. I don't know, but I know we have
Chances
a
are
very,
better.
very high statistical probability of clearing that.
Right.
Now, once you clear it, now that's payday, in a way. You're there. Everything in your trust, there's nothing that can be done. Because even when you put property in this asset protection trust, there is only one thing that they can do, and that is impose a penalty period.
Yeah.
There's 3 things we want to guard against. We want to guard against the asset being available for the cost of care. I'll just refer to that as them getting at it. Okay?
Yeah.
It's not that they get at it, they just make you use it to pay for your care.
Yes.
The second thing is estate recovery, which happens after your death. Is how they get paid for you. Paying for you is they want paid back, and they go after what's in your estate.
Yeah.
The third thing is the penalty period. Well, the minute we put it into the trust, it's no longer a countable asset by virtue of being in the trust.
Yeah.
And now they can't get at it.
Yeah.
The day you put it in. And we do that sometimes with family farm that has to be saved. You know, somebody comes to me, we got this family farm and 3 families are working it depending on the income. And Gertrude owns it and she's in a nursing home. What do we do? If we lose the farm, a lot of people are in SOL, you know. And so, first thing we do is put it with these asset protection trusts. Now the farm is going to survive.
Right.
But we may have to deal with a penalty period because putting something into a trust, you are divesting yourself of it.
Yeah.
And then when you divest yourself of anything and don't get paid for it, it's called a divestment and it triggers a penalty period. I forgot to look at the clock. Where are we?
We got about a little more than a minute.
Oh, okay. So anyway,
A lot of stuff this morning.
you know, so yeah, that's when we do this planning, it contemplates all that and more.
Yeah.
You know, and it puts you in a great position should anything bad happen to you. Even up to the bad thing happening to you is death. Okay. So anyway, again, seminar coming up week from tomorrow.
Yeah, that's right.
WLX at the back of the station. The address is 1212 North Locust Avenue, Lawrenceburg. If you're here, you know where it is. 10 o'clock, Will's Trust of the Nursing Home. Come on, you can walk in if you need to, but appreciate a head count if you can give that to us. So give me a call at Pierchoski Estate Law, Pierchoski Elder Law. The phone number is 931-363-7222. Or you can go to estateplanstand.com. And we're here every Friday morning from 8 to 9 with Bulletproof Estate Planning for you to interact, ask questions, and share experiences.
Absolutely. Stan Pierchoski, everybody, with Pierchoski Estate Law in Pulaski, Tennessee. And of course, here on Friday mornings. And don't forget that seminar.
Yep, next, the 28th at 10 o'clock here at the radio station.
See you next time.
WD Lawrenceburg, broadcast
Right on the money.
Prospect
Right?
Communications.
Yep.
I was